Good morning, ladies and gentlemen. Can I begin the meeting with the usual admonition for everyone to switch off mobile phones? We have no apologies as we have a full turnout. Item 1 relates to the Criminal Justice and Licensing Scotland Bill. Members should have before them the written submissions from the judges of the High Court of Justiciary and the SPIFE briefing papers. Can I welcome the witnesses for this morning? First of all, Lord Hamilton, Lord President of the Court of Session, though perhaps more appropriately in this particular locus as the Lord Justice General, the Lord Justice Clerk, Lord Gill and Carolyn Breeds, the Deputy Legal Secretary to the Lord President. I am aware, Lord President, of the commitments which you have at the Appeal Court this morning, so we will attempt to get through the business as expeditiously as possible. We have the paper before us, so we will move straight to questioning, which I will open by asking you why, in your written evidence, you state that the current range of mechanisms for exploring and developing sentencing issues could be improved. Could you provide the committee with a brief overview of those mechanisms and suggest ways in which they could, in fact, be made better?
Sure whether I'm wired up or not.
You're completely wired for sound.
That's splendid. Well, I think as we indicate in the paper that there are a number of existing mechanisms for seeking to secure consistency of sentencing. They involve the general framework of decisions by judges, particularly judges of the High Court sitting on matters of appeal. They involve the facility which the High Court has of itself issuing guideline judgments, which it did only to a limited extent initially, but which I think there is a measure of momentum of that being built up. There is the position in relation to other mechanisms such as Crown appeals, where the Lord Advocate herself is making use of at present 2 appeals in murder cases, seeking general guidance from the court in relation to the range of punishment parts for those sentenced to life imprisonment for murder. And we've also had a system in place for some time now, under which originally Lord McFadden and now Lord Carloway are involved in identifying or seeking to identify cases coming on appeal which might be suitable for guideline judgments. And therefore we're being alert to that. There is, I think, a prospect of that being improved upon and extended in the sense that what I have suggested to him and which he is now considering as to whether or not we should have something like a reference body which might include members of the profession, other judicial office holders such as sheriffs or justices, and conceivably also persons from the outside community who might put their particular contributions into that particular exercise and identify particular areas in which it might be useful if we can issue guideline judgments on matters which we haven't done so already. That is the sort of line which I had envisaged.
I did note with interest that Lord Carloway is now carrying out that exercise. Can you advise what criteria he is applying in identifying appropriate cases?
Well, I'm not sure I've identified any specific criteria. It is cases in which there would appear to be a generality of concern, ones in which matters are not simply special to the particular circumstances of the case itself, but ones in which there appears to be general matters that arise.
It appears, and this again is in your paper, that there is a view that there is scant evidence being produced that there is inconsistency in sentencing, although the public perception perhaps is that this is the case. Have you any views as to what action could be taken to overcome this perception?
Well, as we say in the paper, there is and has been recognised as being no empirical evidence to suggest that there is inconsistency in sentencing. Of course, one needs to understand what consistency of sentencing is in the first place. If one understands by that in broadly similar circumstances of offence and offenders, there should in general be an attraction of a broadly similar sentence, then I find no difficulty at all with that, and that appears to be an appropriate part of a well-ordered criminal justice system. But so far as Scotland is concerned, I'm not aware, and no one has brought to my attention, any empirical evidence to suggest that there is inconsistency of sentences. And I'm particularly concerned that this particular proposal may involve the expenditure of a substantial amount of funds on a particular exercise without the premise being examined as to whether there truly is an inconsistency of sentences. Now, what I have offered to the Cabinet Secretary of Justice, I think on more than one occasion, is to open the doors of the Justiciary Office to the records that we have there in relation to cases in which either the prosecutor or the convicted person has appealed against sentence, whether or not in the convicted person situation leave to appeal has been granted, in either of the situations what has happened if leave has been granted and the matter has been dealt with in the appeal court, and lastly what the appeal court has done in the particular circumstances, so that an empirical exercise could be carried out to identify whether across the board there was any true inconsistency of sentences. Now, if that were done, and I make the offer to the Parliament now in that regard, if that were done, then one could discover, first of all, whether there was in fact an inconsistency of sentences. If there was no inconsistency of sentences, the appropriate exercise would be to dispel the false impression that there is an inconsistency, and if there was an inconsistency of sentences, then the appropriate stage at that time would be address that matter and see what the best way to cure it was. So that offer is open.
We will take that under consideration, Lord President. The other principal issue which arises from your paper is the concerns that you express that the Sentencing Council, as proposed, would undermine the independence of the judiciary. Clearly, it would be inappropriate for politicians to interfere in individual cases. I think there would be general acceptance of that. However, why might it be considered unconstitutional for a Parliament to establish an independent body to produce general sentencing guidelines? It has been done in other jurisdictions.
What I think one has to recognise in this particular field is the radical difference between the proposals now made and the proposals that were made by the Sentencing Commission, chaired by Lord McFadyen. That commission recognised the importance of the High Court of Justiciary as the senior criminal court in Scotland being the ultimate body responsible for laying down sentencing guidelines. It saw the advantage, and I can see the advantage, in there being an advisory body with research facility for undertaking exercises and putting the matters before the appeal court for endorsement or otherwise, as the case may be. However, I think a situation in which an outside body, which is not itself an elected body, and which comprises, as the present proposals indicate, a majority of non-judicial office holders, does impinge upon the independence of the judiciary if it is going to lay down what are in effect prescriptive guidelines in relation to these matters. So far as I understand, in England and Wales, the situation is that eventually it is a majority of judicial office holders who sit, at least at the moment, on the Sentencing Guidelines Council. And I think in our jurisdiction, it's been recognised, I think, most recently in the Judiciary Act, that the judiciary is itself an arm of government and has important functions to fulfil. And that, I think, would properly be recognised by a scheme in which, ultimately, the laying down of the guidelines was reserved, as it has traditionally been reserved, to the highest criminal court in this country.
Thank you. Lord Gill, at this stage, of anything you would like to introduce into our discussions?
Well, I'm slightly troubled by the term inconsistency. Forgive me if I just go back slightly to an earlier part of the discussion, but it does run into the point that's just been raised with the Lord Justice General. If this legislation sets out to achieve what is described as consistency, then it seems to me that it is essential that it defines what consistency and inconsistency actually are. The consultation paper started off by talking about inconsistency and then spoke of a perception of inconsistency, which is rather a different thing. And it's not quite clear yet what it is that this legislation seeks to achieve. There is no definition of consistency in it, in the draft. And it seems to me that those